I'd like to welcome everyone to today's webinar, Preparing for the Worst, a breach notification under the GDPR. Thank you for joining us today. In today's session, our guest presenter will address critical aspects of the breach notification under the GDPR, including how does breach notification differ from incident response? What qualifies as a breach? What information do you need to provide DPAs or data protection authorities? What are the roles and responsibilities for your team? Addressing notification responsibilities in data processing agreements, and how data discovery and classification can help you better prepared in some aspects. So at this time, I'd like to introduce our guest speaker. Joining us today is Scott Giordano, a highly regarded data privacy attorney with over 20 years of practical experience and currently a director at Robert Half Legal. So welcome, Scott.
What's interesting about breach notification is that this is one of two particularly tough areas for GDPR compliance, and I spend all day, every day, and probably will until June on GDPR compliance because there's been just so much demand for advice on this. And so it's interesting, breach notification and data subject access requests, or DSARs, the two really hot areas right now of all the hot areas in GDPR. And the reason is because the standard is so high. So if you're a data controller, and that's to say that you have the last word on how data is being used, EU personal data, then, and there's a breach, which we'll talk about in a bit, then you have 72 hours from the time you become aware, I'm using air quotes here, but the time you become aware of that breach to notify a supervisory authority, or what's called a data protection authority. For example, in the UK, it would be the ICO, the Information Commissioner's Office. So you've got 72 hours to notify that organization and potentially notify the data subjects if there is a quote-unquote high risk to their rights and freedoms, as is often said in the GDPR. So that's a very short window, that 72 hours, very, very short window to be able to do that. And so we're going to talk about that. These 45 minutes. And so, yeah, I do want to encourage questions about this because I get all kinds of questions every day about this. The breach threshold it's called a reasonable degree of certainty that a security incident has occurred and has led to personal data being compromised. So that's for the data controllers. Data processors have a similar requirement. And frankly, I think in future GDPR changes, they'll probably just make it the same requirement. Right now, data processors, so a third party, say that you have Amazon Web Services or Azure or something like that, or it could be any third party that really is holding your data, then you have to be notified as a controller. You have to be notified by them without undue delay, also known as promptly, and again, using air quotes here. In terms of the breach threshold, this is presumably the same as it would be for the controller. They don't quite come out and say that, but I think it's safe to say that that's the same threshold. Now, what's interesting for data processors is that you don't have to determine whether there's a high risk or even much of a risk. You just have to determine that a breach occurred, and you have to notify the data controller. Up to the data controller to really evaluate whether there is what kind of a risk, whether it's a high or a regular risk, if you will. Also, note that there's no de minimis requirement here. You could have a breach of one person, and you're captured by GDPR. I know here in the States, there are, in some cases, de minimis requirements that it need a certain threshold of records. Not the case under GDPR. This is why this is so difficult. Also, very fortunately, this morning, an update came from the Article 29 Working Party on breach notification, of all things. So very fortunate. And it's called WP 250. Rev 1, I believe it is, just came out this morning, or at least I got my hands on it this morning. Highly recommend everyone take a look at that after the webcast. Appendix B has 10 very good scenarios of what is considered a high risk. And so I highly recommend that you go have a look at that. So with that, let's go to the next slide.
Scott, a question for you.
Sure.
For the benefit of our audience, is EU personal data the same as PII, or personally identifiable information?
Good question. No, it is not. I'm glad you asked that. It is not at all. And here's why. Personal data, EU personal data, is a much broader concept. So, for example, this idea of an online identifier, sometimes you'll see that cited, which can be anything machine readable. So think about IP address or a MAC address, or a cookie, a browser cookie, all those things are considered personal data. And presumably, if you had a collection of cookies in some database somewhere that was compromised, that's definitely a reportable breach. So it's a much larger scope. And people are shocked. I speak with clients every day about this, and there is a certain look of incredulity when I say, yes, IP addresses, even dynamic ones, are in scope for GDPR, and they're just shocked. So yes, the short answer is that there's a much broader scope of what qualifies as personal data under GDPR. Yeah, please do.
How is the severity of risk being high, low, et cetera? Well, I'll just read the question as it's written. Be identified so that necessary notifications can be made by data controllers.
They don't give a definition of what qualifies as high risk, and I don't know if there ever will be one. That's the problem. Really, it's up to you on a case-by-case basis. And here's another interesting dichotomy that you'll find here. In the Article 29 Working Group paper on data protection impact assessments, they have criteria as to what qualifies, or I should say, what questions you have to ask that would lead you to determine what qualifies as high risk. Now, the paper that just came out this morning, however, said, you know what, that's great for DPIAs, but you really don't necessarily want to use that for breaches. You want to look at the breach as it occurred at the time and get an idea of whether it's a high risk. So we don't have a standard. We may never have one because it's so subjective. So as a practical matter, you have to ask yourself, just how damaging could this be? And I'll give you some pretty blatant examples. I mean, you all remember in the audience, you'll remember the Ashley Madison hack that happened, and all of that very lurid data that is now presumably available everywhere. That, no question, high risk. There was a credit reporting agency hack that happened a couple months ago, Equifax, that was pretty extensive. And you can pretty much guess that intimate data there, for example, salaries and so on and so forth, is something that potentially is a high risk. Yahoo, that was hacked. That could potentially, depending on the hack and the data that was compromised, that could be as well. So the net of it is there's never going to be a standard. It's always going to be, in my view, a case-by-case basis. And you just have to ask yourself, what if this were my data, would I be concerned about it? Would it present a high risk to me? I think that's a safe as metric as any.
Great, thank you, Scott. Two more questions. Or is there an overall supervisory authority for all of EU, or is it country specific?
It is country specific. So you might then ask, well, great, Scott, so if I have business all over the EU, do I have to notify all 28 EU data protection authorities? And the answer is no. Strictly speaking, you only have to notify your lead data protection authority. That's per the working party. However, and this is an important however, it is optional for you to notify all the rest of them. And personally, if I were a DPO or a chief privacy officer, I'd be notifying them as well, just because you don't know how great a job that the lead DPO, or I'm sorry, the lead DPA is going to do. And suppose they take a couple days, or suppose they're short-staffed. I mean, right now, DPAs are losing people left and right because they're going to private practice and they're becoming DPOs. So the net of it is that if you think it's a high risk, I'd notify all of the DPAs in the respective EU member states within 72 hours and not rely on your lead, because you just don't know how good they're going to be at it.
Okay, a couple more questions, Scott. Sure. Aren't city-states also a factor? For example, Germany requirements for DPOs.
They're a factor in the sense that if you have a DPO, the DPO is probably going to be in the driver's seat for doing this in the first place. Almost certainly they're going to be the ones that are going to be running this whole breach notification process. So in that sense, whether you have a German DPO, quote unquote, or a EU DPO, I think the role is going to be the same. They're going to be running the whole thing, and they'll be well versed with doing that. Obviously, if it's a German-only DPO, then it's going to be confined to Germany. But as a practical matter, could that person also be your EU DPO? In theory, it could. There's a lot of legalities involved in that, though, and not all companies are going to want to do that. But it's going to have to be something that your own inside counsel or outside counsel is going to have to advise you on.
So EU data was defined prior to GDPR, correct? And then cookies, TCP/IP addresses, et cetera. have been in scope for EU PI since the EU directive. GDPR is specifically clarifying the protections for data subjects, fees and fines if not met. This person wants to just validate, is this correct?
It's correct that case law has developed that different pieces of information, like cookies or dynamic IP addresses, have over the past 20 years been identified or articulated as personal data and therefore subject for breach notification. If that's what your listener is asking, yes, it's been bits and pieces here and there from different DPAs and from court cases. So penalties, two different kinds of penalties, and presumably they're all going to be rolled into one, but up to 2% of the offending organization's annual worldwide gross revenue for failing to report the breach, and then up to 2% for the underlying weaknesses in its information security capabilities. So I think all of your listeners are all well versed with the 4% potential, and it's a real potential, and there's no doubt that that organizations are going to be levied some big fines. I know the ICO has levied some massive ones, at least under their law, under their version of the Data Protection Directive, and believe me, they'll continue to be levying those. I know in one case, a hospital was fined, I think, £200,000 for sending out transcript information, and when the transcriber finished it, they didn't put a firewall up, and so it was accessible to the whole world. So that was pretty embarrassing. So you can bet that we're going to see some pretty steep fines here.
Okay, Scott.
Yeah.
Could you have a breach but no underlying weakness in your information security capabilities?
In theory, you could. I'd be shocked if you had a breach and did not have an underlying weakness, but I suppose theoretically it's possible. I know occasionally you'll find that people will say, oh, I couldn't prevent this because it was a state actor that did this, or there was an advanced persistent threat or something like that. I mean, really the vast majority of breaches happened because of just basic negligence, not patching a system, for example, or just poor training on the part of employees. So I'd be very surprised if that were the case.
How is non-compliance going to be determined?
How is non-compliance? Well, one way is simply failing to report the breach. That's easy. We had that case with Yahoo where there was, I believe, 3 separate breaches that were not reported. And certainly if those had happened in the EU, that would have been, after GDPR, that would have been a big deal, not surprisingly. So I think that not reporting it is really what's going to get you. But even if you reported it and it's obvious that you were not doing a very good job on your information security posture, I think that's going to be the way that you'll be penalized. There will be an investigation, much like there is here in the U.S., where the FTC will investigate after a serious breach and determine that just basic computer security and policies and procedures weren't followed. So I imagine the same will happen in the EU.
Okay, great. Another comment from a participant: example of being compliant in theory, the company may be compliant, but subcontracted services without appropriate controls can cause a breach, like the Target breach.
Yes. Yeah, but that's true. But then you can make the argument that they're not truly compliant because they have to ride herd on their third parties. And believe me, folks, I know it's not easy to do that. I'm not suggesting that you're gonna be able to just, as a matter of course, rely on your third parties, because you may have dozens or scores of them that have personal data. And in fact, when I do data inventories with clients, you're going to find that maybe 2/3 of the applications that process personal data are held by third parties. So it's not an easy thing to do, but you do have to ride herd on these folks. Otherwise, they will be the weak link in the chain for you.
So this same person asks, do you see the potential that Dawn RAID model may be the audit approach for GDPR risk compliance?
Potentially, but you think about it, it's so much easier just to find a breach that's already happened and just go after that entity. Because typically these entities are multinational, or they're multi-EU for sure, so they're going to be in more than one member state. And so that's easy money for them. You've already got a breach. So I suspect, yeah, you could use a Dawn RAID model, but if you really want to make things easy for yourself, just go after and chase all the breaches. And I mean, that's easy money for you right there.
Great. Just one last question, then we'll move on to the next slide. What would happen if the kind of breaches that took place with, say, Yahoo took place under GDPR?
They would be an absolute train wreck for the offender. Certainly, if Yahoo was in the EU, had all that, however many, I think it was 1.3 billion records or something like that were affected, it would be a financial train wreck. for Yahoo. I mean, ultimately it was anyway when they were sold, but it would be more so than that, just because it was just so poorly addressed. So yeah, don't definitely learn lessons of Yahoo. Don't repeat those mistakes.
Great, thank you.
Okay, so how does a breach notification differ from incident response? Whenever I talk to clients about this, a lot of times they use the terms interchangeably, and they are not the same thing. So let's just look at incident and incident response. Incident, and I'm using NIST SP 800-61, which is a guide on incident response of all things, talks about it as a violation or imminent threat of violation of computer security practices, acceptable use policies, or standard security practices. So it's really looking at a bad thing that's happening, and then of course how you're responding to it. And so typically this means that you have your InfoSec folks go and jump on it and find the bad guy and seal off the network and go look for evidence and all those good things, which are very important. There's the whole idea of the cyber kill chain and all that. If there's any InfoSec folks on your broadcast here, they're familiar with cyber kill chain. That's all great. But that's really about battling the bad guys. It's not about breach notification, which is mitigating the damage to individuals, and it's also notifying the proper authorities. So you really, for breach notification, are determining just what personal data is involved, getting meaningful information to the supervisory authorities and the data subjects. And then it begs the question, of course, suppose you have data that you shouldn't have had in the first place, should you still notify the data subjects and the data protection authority? The answer is absolutely yes. So I've gotten that question before, because in many cases organizations have data that they really shouldn't have. They bought it from a third party, or they never got a proper consent, or whatever it is. Yes, you still definitely should notify. Don't make things worse by not doing so. Okay. So some examples: breach notification versus incident response. So these are all from 861. So I'll just zip through these. So attacker sending commands of botnet to take down your server, or tricking a user using a phishing email or something like that, and uploading malware to your system. Attacker gets sensitive data and tries to extort information. Presumably they've already gotten on the network and gotten in the information, or perhaps they bought it from a third party that got it. Or a user exposes sensitive information through peer-to-peer file sharing services. I don't know if those are as popular as they used to be, but they're a great way to lose personal data. So these are all examples of incident response related areas, because it may be that personal data is involved, but at a very minimum, they all merit their own response. And so that's, again, we'll talk more about why the legal team, the breach notification team, needs to work very closely with the information security folks. So let's go to the next one.
Okay, just a few questions.
Sure.
So are these breach notification examples?
These are incident response. I'm sorry, this came from 800-61.
Thanks for the clarification. A question from the previous slide. So from a flow perspective, the incident may drive or result in a breach notification review or decision.
Oh, yeah, absolutely. Because in theory, you could have an incident that doesn't affect personal data. Maybe it affects intellectual property, certainly, but at a minimum, personal data is not implicated unless maybe the author's name is on the intellectual property document. So in theory, you could have an incident without a breach notification being necessary, but at the base, you're always going to have the incident response first, and then the breach notification layered on top of that.
Great, thanks. One more question. Is the assumption with GDPR that if a data controller can't determine the scope of the breach, they must assume that the entire data has been breached?
Absolutely, absolutely. Because if you don't know what the scope is, you're going to have to assume the worst. Because if you don't, and it turns out that all that data really is floating around on the internet, and bad guys are buying it and trying to set up accounts, credit card accounts or something, then it's going to come back to bite you. So you really have to presume that if you can't quantify it, that everything's in scope. Again, why it's so important to be able to quantify that ahead of time. So let's talk about what qualifies as a breach. So Article 4, Sub 12 of GDPR talks about a breach as a breach of security that's leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data transmitted, stored, or otherwise processed. So, I mean, that's the textbook definition, if you will. But the larger question, though, is, well, what does that translate into? What's interesting is that Article 29 Working Party talks about this in terms of a breach in confidentiality, a breach in integrity, or a breach in availability. So those of you familiar with the CIA triad, same idea. It is the idea, essentially. So different species of breaches that you could have. And they give a couple examples here. So data's been deleted accidentally, or perhaps by an authorized person, or if there's encrypted data, the decryption key is lost. Another example is a loss of availability if you have disruption to the normal service of the organization. So you have a power failure, a DOS, denial of service attack, and the data is available even temporarily. So very interesting. Really, as a practical matter, as I said earlier, if there's a breach, then and whether the breach is reportable, it's going to be very subjective, and you're going to have to determine it on a case-by-case basis.
So Scott, doesn't it seem a bit ridiculous to say that a breach has happened from a power failure?
It does seem ridiculous, but if you look at Appendix B of the updated WP 250, really a power failure that is more than a few minutes is potentially going to be something that's reportable. So that's why I recommend everyone take a look at that, because they give a lot of really good examples in Appendix B. And so a short-term power failure, I mean more than a few minutes potentially, is potentially and likely reportable. So this is why this is so important to be able to have a breach notification plan and understand in your own mind what qualifies as a breach and to be able to document it. It may be that you have an incident that doesn't mature into a breach, but it's still something you want to record. And so this is another interesting aspect of this, is that you always want to keep a record of incidents that don't mature into breaches but still have happened, because it may be that you look back over time and go, you know what, it's really strange that we keep having the same bad thing happen, and turn out that it really was a breach. You just didn't realize it because the bad guys were so good. So that's why it's very important to always document incidents in some form or fashion and be able to review them to go, this is strange. What happened here and why does this keep happening? And it may be that a DPA will want to look at that and go, well, give me a list of the incidents you've had over the past 18 months. So this is why record keeping is such an important aspect of compliance for GDPR, not just for this, but for a lot of other things as well.
What about if your data is encrypted by ransomware? Is that a breach?
Yes, that's a breach. And so it's interesting, because I've had this conversation with a lot of folks saying, well, wait a minute, if your data is encrypted, then no one can access it, so it shouldn't be a breach, but you've lost access. So on the CIA triad, you've lost the accessibility to that, and as a consequence, that means that you have to report it. So, and this is something here in the U.S. it's the same. The HIPAA regulations, specifically from Department of Health and Human Services, say if you get malware and malware creates ransomware situation, then you've got to report it as a breach. Now, our reporting requirements are a lot, I won't say they're more lax, but you have a lot more latitude. I think it's 60 days to report as opposed to 72 hours, but the principle is still the same. If you get hit with ransomware, pretty much you can consider it a slam dunk as a breach.
So if the data is encrypted and it isn't accessible to the bad actor, is it a reportable breach or just a security incident if they didn't access the data?
I'm going to call it a reportable breach because you've lost access. The end user has lost access. So that's an important aspect to keep in mind. And again, I know this may seem ridiculous, but if you've lost access and it's either permanent or close to permanent, or it's even extended. Again, the example before where if you have, say, 20 or 30 minutes of lack of access because of some kind of power outage, in theory, it's a reportable incident. Again, look at Appendix B. I was kind of surprised at some of the scenarios there. So the net of it is that losing access is a reportable incident. Now, does that mean there's a high risk? Not necessarily, but you don't need a high risk to require it to be reported to a DPA. So keep that in mind as well.
Great. What about innocuous data like GPS data? Would losing that still be considered a breach?
Innocuous data, if you have enough of it, is going to be something that's personally exploitable. And it's interesting because you think about it, if you have enough of any kind of data and you're able to accumulate that, and GPS data is a great example. because just imagine you got a person's all of their GPS data everywhere they go, pulled it off their phone. Even if you didn't know that person's identity, you can find out an awful lot about that person. So at some point, as I like to say, numbers do count. And so even if it's so-called innocuous data, you still have to consider what's going to be the cumulative effect if you got enough of that. And as a consequence, I would say, yes, that's reportable.
Great, thanks. Just two more questions, if that's okay,
Sure.
on this slide.
Sure.
Who needs to have availability to the data? For example, if my company still has access, but the end owner does not have access to deny use, is the data still available?
No. I mean, if the end user, the customer, quote unquote, or the data subject doesn't have access to it, then that's reportable. Unless it's, again, more than a few minutes, as seems to be in Appendix B of WP 250, it seems to me that if the end user can't have access, then it's reportable.
Okay, great. Last question for this slide. Does the GDPR apply if a EU resident visits the US and gives their personal information to a US government agency, which then has a breach?
Oh boy, that's a wonderful question. I mean, the short answer is no. So just showing up to the U.S. on vacation, and for example, a U.S. government agency gets it. Now, does that mean that government agencies not subject to Privacy Act of '74? No, they still are, and that's essentially the U.S. version of the data subject access request. So under GDPR, the answer is no, but still certainly under Privacy Act of '74. Presumably you'd be able to file your equivalent of a DSAR and be able to get that information.
Okay, thank you very much, Scott. Moving to the next
Sure.
slide.
Sure. When does the clock start? Again, I get this question all the time. It's when the controller is aware. And when are they aware? When there's a reasonable degree of certainty. And so the emphasis should be on prompt action, not counting minutes and saying, well, we need to wait 20 more minutes or 30 more minutes. Prompt action really is what should be driving you. If there's a reasonable degree of certainty that the bad guys have gotten the data or they've simply denied access to your end users, then that's when the clock starts and you become aware. If your third party notifies you and says, hey, we got hacked, then the clock starts immediately. They don't have to evaluate whether there's a high risk, low risk, medium risk, what have you. Just tells you, hey, we got hacked, guess what? Now you're aware, now the clock starts. This is why it's so important to have a plan ready to go and you've practiced it before you have to actually put it into action, because those 72 hours are going to go real fast. Okay, so some examples of when the clock starts. So these are really fascinating. I definitely recommend everyone digging into this and reading these after the broadcast is over. Case of a loss of a CD with unencrypted data. I mean, CDs can hold a ton of stuff. So unencrypted data, you've lost it and can't really ascertain whether bad guys got it. Well, guess what? Got to notify. The third party tells you that they've accidentally received personal data of one of the customers. Okay, well, you've become aware. As you can tell, if a third party tells you that there's a problem, you've just become aware. If the controller, that is to say, if you detect there's a possible intrusion, okay, you check, and once again, there's a clear breach, then you become aware. So this is why the Security Operations Center is so important in this whole chain, and we'll talk about that in a couple minutes. A bad actor contacts the controller and demands ransom. We mentioned earlier, ransomware, get a ransomware attack or ransomware communication, then the clock has started. No doubt that the bad guy is inside the wire and they've gotten your data or they've compromised it or just denied access to it. So in all those cases, the clock has started. Okay, what needs to be communicated? So at a minimum, these are the things that need to be communicated. So the nature of the personal data. So categories, approximate number of data subjects, categories, and approximate number of personal data records concerned. So how would you know this? You would know this by looking at your Article 30 record of processing. That is your single source of truth for all of your records. And some of these things get pretty big. I review these with regularity, and they're potentially huge documents that have all kinds of information about all the various processes. And a company will have anywhere from 30 to 120, 150 processes at any one time going on, because you'll have the ones here in the US, you'll have the ones going on in the EU. They may have their own local networks in the EU. and their own firewalls. And as a consequence, you have to account for all of those. And that's going to be in your Article 30 record. Also, name and contact of your DPO if you've got one, or just whoever is on point for the breach notification. Likely consequences of the breach you have to notify. So in some cases, it's going to be pretty obvious, the likely consequences, potentially someone breaking into someone's bank account or creating fraud through credit cards or opening accounts in their name, etc. In some cases, it may be less so. So you're really going to have to take a best guess as to what could happen. Again, another reason why conducting a data protection impact assessment is so important, because that work will already have been done, looking at what the likely consequences are. Again, this is why I put such an emphasis on preparation. Trying to do this after the fact is just not going to work. And then finally, describe the measures taken or proposed to be taken to mitigate. Very, very important. It could be that you got caught and just weren't ready for the breach, but you have taken great pains to mitigate things, whether it's giving someone access to credit reporting or credit monitoring or what have you, or making changes to the database or changing other systems so that the data that was stolen is not otherwise very useful, whatever it might be. But letting the authorities know what you've done to mitigate damages is going to be huge, not just to minimize your fine, which is going to be pretty big, but also just to protect the people whose data has been impacted.
Sure. Sorry to talk over you.
Sure.
Why is time detected not communicated?
I'm not quite sure I follow the question. Can you do it one more time?
Yeah, so the way it's written, the time of the breach, why does the time of the breach detected, why is it not communicated?
You could communicate that. I mean, yeah, I guess my answer is at a minimum, hence why we put it in red, these are the things that you have to communicate to the Data Protection Authority. Presumably, you'd want to give them any meaningful information you can that'll help them notify the people affected potentially, or just minimize the damage. So really, I would take this as a minimum. Really, a solid data protection program is going to be able to provide a lot of useful information to a DPA within that 72 hours, even if you have to do it in stages. So yes, you could definitely communicate the time that you think the breach happened, if that's the question.
I believe that's the question. Thank you.
Okay, sure. Okay. Let's talk about how to prepare for this. So first up, review or update your IR plan. And I like 800-61 as a good template for IR plans. But again, just copying and pasting that and calling it your IR plan is not enough. You're really going to have to pretend that a bad event has happened and walk through all the different things that would take place. So it may be that you have a security operations center or at least a security expert somewhere in your company that is monitoring the network. They're looking at events and logging events and so forth and saying, yes, this event has become an incident, and so therefore it's reportable. And then talking about the different standards, approaches, et cetera, of how you address an incident, and then how you loop in the breach notification people. So very important to be able to have all these things and to have it way ahead of time, to have it practiced. Hopefully you've, unfortunately had one of these happen before, and your team's had some experience in battle, as it were, and so you know how to do these. If not, then really working with your team and getting prepared. Very, very important. Next up is your Article 30 data inventory. And if you listen to any of my webcasts before, you know I'm a big fan of these. And I'm a big fan because it has all the information you're going to need to give to the Data Protection Authority when they ask for it. And they're going to want to know everything. So being able to have that ahead of time is crucial. Being able to validate that you've got that data ahead of time is crucial. Being able to talk to your application owners, whether they're business owners, technical owners, getting an idea of what the data is, all the details about it, that's going to be so important up front to be able to have that. If not surprisingly, data discovery and classification is very helpful in this aspect, because you want to be able to validate where the data is. A lot of times there's data that you don't know is on the network. It's been forgotten. It's orphaned somewhere on a server, but the bad guys found it. So keep that in mind as well. You always want to validate whenever you can construct your data inventory. And I think the next slide has a picture of it, Doug, if not mistaken. Yeah, it does. Okay. Again, I know this is somewhat crude in the sense that I've made a lot of these items here just theoretical, but really this is what your data inventory is going to probably start off as, and then you're going to build from there. So you're going to have things like, well, what's the activity that's in respect? So I call it Employee Central. You can call it any kind of a HR system. Sell me stuff. So think about all the CRM systems out there. Reimburse me. Think about all of the payment reimbursement programs that may be out there. These are the kind of things that are going to have personal data. And so you want to know all the information that's relevant. All who are the data subjects, what's the personal data, who's getting them. So for example, your HR systems all are going to have all kinds of third parties, or at least internal processes they're going to have access. So your payroll, your travel agencies, LMS, your benefit providers, all of that. The question is it being transferred outside of the EU? Very important to know that. It may be that the data started off in the EU and came here to the US or went to another country, or perhaps it came to the US and people in another country are remoting in to look at it to do updates or what have you. Is there a data transfer mechanism? Probably a good idea to review that and see what you're using to legitimately bring the data to the US in the first place. And then, who's owning that? Who's the business owner? Who's the technical owner? Being able to ask them for more information. And finally, what technical measures are you putting in place to prevent, in theory, or try to prevent the hack from happening in the first place? So all that's very important. All part of the inventory. This is the bare minimum inventory. You're really going to want to add a lot more to this, but this is at least a place to get you started.
Great. A question, is there a requirement restriction for processing personal data of a EU data subject to India and processing their data in India?
You can do it. It's not a problem from a legal standpoint, but there has to be a transfer mechanism. So say, for example, that you're processing, you have personal data that is being processed on a server in India. Okay, or you have someone from India remoting into your server in the EU, and that's considered a virtual transfer of data because you're looking at the personal data. You have to have a data transfer agreement with that person, that organization in India. So it's legitimate to do so, but you have to have that agreement, and you're probably going to wind up using model contract clauses to be able to do that. So typically, and what I do is I write what's called a DPA, a data processing addendum, and so it highlights the contract involved, all the terms, the Article 28 requirements, the mechanism, which typically is going to be the model contract clauses. So all of that is almost always required. I can't think of a place or time where it has not been. So that's something that, yes, if you want to send to India, it's fine, but the party that has it in India is going to have to meet the terms of that data protection addendum, and the bar is very high. So just be warned, a lot of folks may sign these things not realizing just what they're signing.
Got it. A participant comments that India has unique encryption challenges that from a security perspective make hosting or storing data versus accessing potentially more difficult.
Well, if that's the case, you may want to think twice about hosting. If the server is in India, think twice about hosting there. And again, I'm not an expert on what's going to be adequate from a technical standpoint. You're going to have to talk with your InfoSec folks about that and say, you know what, we think that based on what we know, their encryption is okay. Or if it's substandard, or they just can't meet the terms of the data processing addendum, then you just can't host it there. You may be able to have them remote in, but you can't have them hosting it there. So this is why it's so important to have InfoSec folks and legal folks work together on this, because it's just too easy to get this wrong.
Great. So a participant comments that this chart looks great, but wouldn't it make sense to have it broadly defined to cover all personal information within these systems for all privacy laws?
It would be. This is a starting point, and I prepared those before. They take a while. So if you're trying to get compliant by May 25th, get what you can onto a spreadsheet as fast as you can and start validating the data you already have. But then, yeah, build on it, and you should have everything that you're subject to, not just EU. It may be, if you're a global organization, you're going to have it in multiple countries. I know that certainly in Asia Pacific, South Korea, Japan have fairly stringent privacy regulations, especially in Korea. You're going to have that. You're going to have to make sure you adhere to those. Also, South America, some countries have very stringent laws. So yes, absolutely. This is just a starting point, but it's a good starting point.
Great. One more question. How do you see binding corporate rules holding up as GDPR matures?
I think given the amount of intellectual capital they've already invested in these things, that it's going to hold up pretty well over time. I know there was just an update to BCRs that just came out, I think, last week or so. It seems like there's regular updates to them, which is great. And remember, there's BCRs for processors and for controllers. I would definitely consider, if you're going to get one, to get both. And here's why. You may be a controller for one aspect of processing data, but you may be a processor for another. So say that you are doing business with another party and you share personal data. They have their primary set of customers and you're a service provider for them, but then you also are a service provider for your own independent set of customers. You could really have a situation where you're both a controller and a processor for personal data. And really, if you're going to invest in BCRs, to the extent possible, get both of them because really the requirements are going to be more or less the same.
Okay, great. Just one last question. Does the GDPR apply directly to a state agency, and would it apply indirectly to a state agency through a third-party vendor?
It definitely applies to government agencies. So in theory, if they mean a state, meaning a U.S. state agency, which I presume is what they mean, then yes, if they got a set of EU personal data, absolutely they'd have to comply with it. And if a contractor got that data from them, then they would have to comply with that, no question about it. If the state got it from the contractor, which I don't know how they would, but if they got it, they'd still have to comply with it. But I presume the former scenario is the one that the viewer is describing. So yes, absolutely they would. Now, of course, people are going to ask, well, how's the EU going to enforce it? And as I've said many times, the EU is going to enforce it by leaning on the U.S. government to go lean on the states or contractors, whoever it is, to enforce our own laws and to enforce GDPR indirectly. There's no question in my mind that's going to happen just because the Department of Commerce doesn't want to lose Privacy Shield like they did last time. So I think that's the reason you're going to see that. Okay, let's go to the breach notification plan. And breach notification plan really has three big components, if you will. It's got the who. So this is going to be the core team of folks involved. Not surprisingly, at the top of the list, legal, HR, InfoSec, and then your affected lines of business leaders, because they're going to know the most about the data, at least I would hope so. So that's going to be your core team pretty much as a minimum. HR is almost always involved because it's so easy for HR data, because it's so prevalent, to be implicated in a breach. Then you'll have your extended team. So the media or PR team that you have, the finance folks that are going to have to pay for this whole thing. The insurance carrier is going to want to know, especially since that may be part of the policy that they have to be notified with a certain time. Law enforcement will likely have to be notified. So just as a practical matter, once the core team is rolling, you'll then bring in the extended team. If a third-party processor is involved, they've got to be involved. A lot of times they're not going to have the capability of doing a great job, so it's going to be up to you to be able to lead in that respect. And you should sketch out who's going to do what ahead of time, especially with third parties. You want to define that in a contract, who's responsible for what the time limits are. I know that under GDPR, it's the third parties should notify you without undue delay. I would put a number in the contract and say 72 hours or something like that. Otherwise, they're going to say, oh, well, we thought our delay was not undue. So define that in the contract. Don't leave that up to chance.
What is the who in the BN plan? Is that who will notify?
Well, yeah, the who is who will do all the work. So who will do the notifying? So in the core team, for example, you may say, okay, as a consequence of losing these records, that we know that the DPA of the UK, for example, the ICO is going to have to be notified as the lead DPA. Okay, great. So someone in legal will draft a letter and email them and send them a fax or whatever it is. So that's the who. That's who's involved in actually the notification process. It may be that you have the PR team put together a notification for the affected data subjects. If it's too hard to find them, then putting out a press release or something like that may be also in order. So at a minimum, though, it's going to be legal really having to do this and notifying these folks immediately.
There's a two-part question here. I'll just read it as is. What about customer information owners or IT operational teams For example, if the right to be forgotten cannot be applied, and then continues, is ability to meet a requirement like right to be forgotten a breach?
No, it's not. I mean, because presumably, even if you're not meeting right to be forgotten for legitimate reasons, okay, say for example that you've got a 7-year requirement to hold the data because it's SEC mandated or FINRA mandated that you hold it. The fact that right to be forgotten is not applicable, or you defeated their right to be forgotten, that doesn't make it a breach. It's only a breach if you lose control of data, bad guys get it, or it's been encrypted and you can't get access to it. So yeah, definitely don't confuse the two. If you've legally defeated right to be forgotten, it's not a breach. You just have to treat it like any other data that has to be protected.
One more question. Would the GDPR apply to a software company who operates a SaaS platform where it's merely a data processor? For example, they're based in the US, they sell only to businesses, not individuals, and are operating their SaaS platform as passively, or is basically passive in its data, or in other words, the company's not really monitoring the data of the EU residents.
It depends on if it's truly SaaS, okay? Because you may have a situation where you're PaaS, meaning that you're providing a platform, but the customer is doing everything else, the rest of the stack. If that's the case, then no, you're not going to be required to notify, because if the customer really has control over that data. If though you're a SaaS provider and you lose control of it, potentially you could be required to notify just as well as a third party, as well as data controller. So just being a SaaS provider doesn't take you out of the equation. So really have to ask yourself, how high up on the stack are you as a provider? If you're providing just infrastructure or just a platform, then I'd say no. But if you're a SaaS provider, yeah, you're almost certainly going to be involved in the notification process, unless you can demonstrate otherwise that you can't see the data. And that's entirely possible. There are models now out there where you can't see the data. It's invisible to you. If that's the case, you can make the argument you don't have to notify. But my view is, if you get breached, notify your customers, let them make that decision. Don't make it for them. Okay, let's go to the next. So the what in the breach notification plan, and we talked about this throughout the presentation today. Determining what qualifies as data breach. This is something that you want to work out with your legal team internally. Your data protection officer, if you have one, your privacy officer, whoever it is, do that ahead of time. Determine what qualifies as personal data, what qualifies as a breach, who notifies whom. There's a nice flow chart in Appendix B or Appendix A of the WP 250 talking about the whole overall process, which is very nice. Invoking attorney-client privilege. It may be that you have to invoke privilege if you want to protect the evidence involved that you're gathering, and you want to keep it to yourself until you're ready to release the privilege. Then it may be a question of getting your attorney on the phone and saying, hey, we need to do this investigation pursuant to a letter of attorney-client privilege. Again, why you have to have legal involved in this stuff, because they may want to do that. Also, you want to determine what you're going to package up for authorities. You probably want to write your letters ahead of time so that you just have to edit them a little bit. Know your contact information for your authorities, both email and fax, because they still use faxes. It's still a legitimate way to get it to them. And potentially set up a call center if you're a big provider of B2C data, for example, setting up a call center, and so you could handle all the numerous calls that are going to come in, because they're going to come in anyway. You might as well just set up a call center to do that. So that's the what part of a breach notification plan. I don't think there's anything here that's surprising anyone.
A couple questions.
Sure.
Does the following qualify as a breach for the processor? A third party, for example, outsourcer of the controller gets hacked. So does that qualify as a breach for the data processor?
If a third party loses control of data, okay, they become aware of a breach in their own network, where they lose control of the data, and they can tell that it's customer data. Okay, it's their customer, their controller data, if you will. Absolutely, they've got to notify the controller. I mean, you should almost presume as a default, if you're a data processor, you're going to be notifying the controller as soon as you become aware that you've lost control of their data, or it's been encrypted, or any of the other species of interruptions have happened. You definitely want to be able to notify them immediately so that they can then pick up the ball and go from there.
Great. You had mentioned the document. I'm sorry, I wasn't actively listening. What's the name of the document you named as an example on the slide?
There's a document called WP 250, and it is the Working Party, Article 20 Working Party document 250 Rev 1. It just came out a couple days ago. I just got my hands on it this morning. Has a lot of really good examples in the back. Highly recommend it. I haven't read the whole thing. I just got it this morning myself, but highly recommend that the audience go to the appendices, and they have a lot of really good examples there of examples of the kind of breaches that are reportable or are not reportable, as the case may be. So that'll be a good guide. It's not perfect. I disagree with them when they say that the DPIA metrics that you use for high risk aren't the same as you would use for a breach. I think that you can get a lot of value out of that, so I'd recommend that as well. Again, that's my personal view on it, though.
Great. So let's see, a couple more questions.
Sure.
Within the context of B2B, does non-sensitive personal data breach, for example, work phone or work email, require data breach notifications to the DPA, as this would be considered lower risk?
Yeah, this is a headache because in theory, if you had a CRM database, we'll say, for example, they got hacked or you lost control of it or a bad guy froze the whole thing up. The bad news is that all that data is considered personal data, even though it's low risk. And because I mean, what's going to happen? Someone's going to call the person's work phone. I mean, it's not a huge deal from that perspective, but from a legal perspective, unfortunately, CRM data is just as amenable as any other data to breach notification. That's why keeping the stuff from getting out in the first place is so important, because it's just so easy to wind up having to notify a DPA. Now, the other question is, well, what about, is it high risk? Now, I don't consider CRM data high risk, typically. You're just naming a phone number and email address. So you wouldn't necessarily have to notify the individuals, but definitely the DPA. And now the DPA may be getting sick of your notifying them, but you're still, after a while, but you're still gonna have to notify them. So I mean, that's really the net of it.
Thanks.
All right. So let's go to the challenge areas, and we'll close things up here. So challenge areas. Actually, let's zip past the notification plan, Doug. We'll go right to the challenge areas. I want to make sure I get those. So challenge area that you're going to have is, one is identifying the personal data. We talked about that earlier, making sure that you go through and do your Article 30 record of processing so you know what's in there. Second one, third parties. I mentioned this before. Make sure that your third parties are on board with what they have to do. If you have a breach, likely a third party is going to be involved because they have so much of your data. Acknowledging a breach is a political issue, and this is something, again, I'm calling out Yahoo as an example of how not to do things. They had at least 3 major breaches, and we didn't really find out about them until recently, and this was over the past 4 or 5 years. So I understand that if you're a CISO, you're probably worried about getting fired, but as a practical matter, you have to acknowledge a breach, and just from a moral standpoint, waiting years to notify people is just not terribly helpful. I mentioned a couple times about what qualifies as high risk. Go to Appendix B on the WP 250 for some really good examples. I still personally prefer looking at the thresholds criteria for what qualifies as high risk on the DPIA document that the Article 20 Working Group publishes. I believe that's WP 248. So I would look at that personally. I like those criteria because it really helps guide my thinking on what qualifies as high risk. And then finally, don't rely on encryption. I know there's an encryption exception. I'm using air quotes here. Encryption exception, do not rely on it, in my view, because the problem is if you rely on it, I would come back and say, well, how do you know the data in question was encrypted at the time it was compromised? And suppose the data is encrypted, but it was destroyed by a bad guy. You've still just lost the data anyway, and you're going to have to notify your data subjects. So I hope that helps. Let's go to the next slide, Doug, and we can kind of wrap things up here. Just a couple things that I want to impress upon everyone. This is tough to do. 72 hours is not easy. It's going to be tough. That's why getting started is now. Go and do those Article 30 documents, records of processing. Get that going on as soon as you can. I know there's probably about 3 months left before the deadline. Get it done. It's going to be the core document for all of your GDPR processing and really your entire data protection program. So ultimately, the goal is to minimize damage to your data subjects. not just to minimize the amount of effort you have to do. So that's it in a nutshell, Doug. I've got a hard stop, but if there are more questions that we have, if you want to just package them up and send them to me, then I'll take a look at them and get them back to you early next week.
We'll do that. So we'll reply to everybody's unanswered questions via email. Thank you very much, Scott, for joining us, and thank you everybody else for joining today's webinar. Look for our next webinar coming up in approximately 4 to 5 weeks. Thank you again.
Bye-bye.